Greetings, I am Nur Shaslana binti Sheikh Daud, a dedicated third-year law student at the esteemed National University of Malaysia. Today, I am honored to present a comprehensive exploration of a critical topic on sexual crimes against a corpse, analyzing the legal position of selected jurisdictions. The aim of the research paper is to explore the legal aspects of sexual crimes against corpses, which is also known as necrophilia, in specific jurisdictions. The paper seeks to identify legal provisions and approaches in different countries regarding necrophilia. Through a qualitative approach involving data collection, the paper addresses the ambiguities surrounding the criminal classification of necrophilia. It highlights the varying legal positions worldwide, citing examples from different countries such as India, Malaysia, the United States, and the United Kingdom. The paper concludes that the legal status of necrophilia remains uncertain in many countries, emphasizing the importance of considering the privacy and dignity of the deceased. In general, the term necrophilia describes a sick fascination with death and the dead. Necros in Greek means corpse, and philia means love. Together combined, these two words form the term necrophilia. Necrophilia is a psychosexual disorder characterized by a persistent and abnormal sexual attraction, arousal, or engagement with deceased bodies. It involves the individual deriving sexual gratification from activities or fantasies involving corpses. In other words, necrophilia is a description of performing a sexual act upon the corpse of dead human remains. Needless to say, this sort of behavior has been frowned upon in most societies throughout the ages. This behavior is thus considered deviant, as it's often seen as a violation of societal norms and the dignity of the deceased. It is important to approach this topic with sensitivity and respect due to its nature and potential for distressing implications. The challenges surrounding necrophilia includes legal ambiguity and inconsistency across different jurisdictions. While some countries criminalize sexual crimes against corpses to protect the privacy and dignity of the deceased, others lack well-defined legal provisions. The varying positions on necrophilia's legality make it difficult to clearly classify such sexual activity as a criminal act. This difficulty in defining the legal stance is evident even in developed countries where penal provisions related to necrophilia remain vague. The legal uniformity is exemplified by the differences in legal approaches among states in the United States and across countries like India, Malaysia, and the United Kingdom. The variability highlights the complex task of addressing necrophilia as a crime and the need to consider the ethical complications of invading the privacy of the deceased. Moving on, the work of Agrawal in 2009, who is largely considered a leading scholar in this area, contributes to more comprehensive explanation of necrophilia. Agrawal proposed a new classification of necrophilia outlining 10 different types by arranging them in its order of severity. In the United States, India, and Malaysia, necrophilia is still technically legal and not criminalized in these countries. However, in the UK, they have taken a different approach in encountering this issue at hand. The common law does not take different types of necrophilia into account. Instead, it is classified under one general definition, which is under Section 70 of the Sexual Offences Act 2003, which makes it an offence for a person A. intentionally to penetrate any part of the body of a dead person, B. with his penis, or any other part of the body, for example his finger, or any other object, where the penetration is considered sexual. This is to exclude legitimate penetration of corpses, which occurs during an autopsy. This definition of necrophilia is problematic for several reasons. Principally, the definition overlooks Agrawal's typologies of necrophilia, meaning that the severity and the context of the offence is not taken into consideration. For example, Class 2 necrophilias, which is considered romantic necrophiliacs, reflects on the case. An example of a question that may arise when it comes to issues on necrophilia is that, can Class 2 necrophilia, for instance, which is also known as romantic necrophiliacs by Agrawal, be considered a crime? This question can be answered by referring to the 2013 case of a woman sleeping next to her husband's decaying corpse for almost a year after his death. In this situation, it cannot be said that such acts of necrophilia is a crime, as there was no evidence that the wife had penetrated any part of her deceased husband. So it can be argued that she is not liable for prosecution for such reasons. Thus, the legal issue that often arises with this situation is that, can we assume that a partner who keeps their loved one's corpse for years, as he or she cannot find the will to be separated from their partners, is therefore within the law, as long as no penetration of the corpse has occurred? And should we be legislating against this, and if so, under what law should this fall? Such questions still remain unanswered in many countries that still exist in this world. In fact, in the United Kingdom, there were no cases of necrophilia brought forward before the courts prior to 2003, as necrophilia was still considered not illegal. And under the previous Sexual Offences Act of 1956, it was argued that a dead body ceased to have rights in law because a dead body was not a victim. However, currently, under the Reformed Sexual Offences Act 2003, the maximum sentence that can be imposed for the crime of necrophilia is 2 years imprisonment. And whether such laws are sufficient to safeguard this act as a crime is still an unanswered question till this day. Such reform can be seen applied in the 2021 case of David Fuller, who was charged with the maximum sentence of 2 years imprisonment for crimes of necrophilia. This case, in fact, was believed to be the worst case of necrophilia in British legal history, as there were campaigners who were calling for sentences to be increased to a minimum of 10 years for the acts of necrophilia. The facts of the case are as follows. David Fuller killed 2 women in 2 separate attacks in 1987 and abused more than 100 female corpses, including children, in 2 Kent morgues over 12 years while working as a hospital electrician. He was not linked to the 1987 murders until 2020, and it was consequently uncovered that he had also committed numerous acts of necrophilia, managing to gain frequent access to a morgue due to his position as a hospital maintenance supervisor, alongside being in possession of extreme pornography. And in 2021, Fuller received 2 whole life sentences for the murders he committed, and at the same time, he was given concurrent sentences totaling 12 years in respect of sexual offences against 78 deceased females at mortuaries in the Tunbridge Wells Hospital. To conclude this research paper, all acts of necrophilia should not be criminalized under one single definition as per seen under Section 70 of the Sexual Offences Act 2003 in the United Kingdom. This is because I believe acts of necrophilia should be segmentized and criminalized according to the classes that was provided by Agrawal's 2003 research. With these categories, it is understandable that people who had committed such acts of necrophilia like David Fuller can be prosecuted and punished accordingly. With this, it would be a necessary change to help save and preserve the dignity of the corpses and the integrity of the deceased family. That is all from me. Thank you so much.